Imagine being asleep in your own home before sunrise. Your front door explodes off its hinges, a flashbang detonates in your living room. 6 armed federal agents drag you out of a closet at gunpoint. You are half-dressed, your 7-year-old son is screaming, and then the agents look at the mail on your coffee table and realize they raided the wrong house. Now imagine the federal government's response is not an apology. The response is a legal brief arguing that the FBI cannot be sued for any of it because the decision about which house to enter was a discretionary policy judgment. That is the actual fact pattern of a case called Martin versus United States. The family won a unanimous ruling at the Supreme Court in 2025, 9-0. Every single justice agreed the government's argument was wrong, but there is a catch, and that catch is the entire reason this video exists today. The Supreme Court did not end the case. It sent the case back down to the 11th Circuit Court of Appeals to apply a corrected legal framework. The 11th Circuit is now sitting on that decision, and just days ago, the Martin family filed a brand new piece of authority asking the court to rule in their favor based on a fresh appellate decision from a different circuit. The Justice Department is fighting them on every word. So today I am going to walk you through 3 things: what actually happened in the Atlanta house, how the Supreme Court ruled in 2025 and exactly what it ruled, and what the new 5th Circuit case means for the family's chance of winning on remand. Let's go back to October 18, 2017. A residential street in suburban Atlanta. Before dawn, a 6-member FBI SWAT team rolls up with a valid search warrant for a house roughly a block and a half away where suspected gang members were thought to be hiding. The lead agent decides to navigate using his personal cell phone, just the regular GPS app most of us use to find a coffee shop. The GPS routes him to the wrong driveway. The team breaches the front door with a battering ram, detonates a flashbang grenade. Inside the house are Trina Martin, her partner at the time, Toy Cleat, and Martin's 7-year-old son. Trina and Toy are hiding in a hallway closet. Toy is holding a legally owned shotgun because they have no idea who is in their house. The agents pull them out, handcuff them, point firearms at them. They pull Trina out half-dressed. They pull the 7-year-old son out of the same closet. Then one of the agents glances at mail sitting on the coffee table. The address on that mail does not match the address on the warrant. That is the moment the team realizes they hit the wrong house. They release the family, drive 3 houses down and across the street, and execute the warrant at the correct address. No same-day apology was offered. Now here is where this becomes a legal case. The family sued under the Federal Tort Claims Act. That law is called the FTCA from here on because saying the full name every time is going to wear on you. The FTCA is the statute that lets you sue the federal government when one of its employees injures you in a way that would be a tort if a private person did it. Assault, battery, false arrest, emotional distress. All of those would have been torts if the people kicking your door down had been ordinary citizens. But the FTCA has carve-outs. 2 of them are at the heart of this case. The first is called the discretionary function exception in Section 2680A. It says the government cannot be sued for a federal employee's exercise of a discretionary function, meaning a policy judgment. The idea is that courts should not be in the business of second-guessing policy choices through tort lawsuits. The second is the intentional tort exception in Section 2680H. That section originally barred suits for assault and battery, but Congress amended it to include what is called the law enforcement proviso. That proviso says when the people committing the assault or battery are federal law enforcement officers, the assault and battery claims come back to life. They can be sued. The Justice Department argued in this case that the discretionary function exception controlled because the decision to assemble a SWAT team and execute a warrant was a policy judgment. They also argued, and this is the piece the source video does not name, that the Supremacy Clause of the Constitution protects federal officers from being held to state law tort standards when they are carrying out federal policy. The 11th Circuit bought that Supremacy Clause argument and threw the case out. Now picture that posture for a moment. The Court of Appeals just told a family that the United States can break down the wrong door, detonate a flashbang in the living room, point guns at a 7-year-old, and walk away free of liability because the Supremacy Clause shields federal employees from state tort law. That is what the Supreme Court reviewed. On June 12, 2025, the Supreme Court issued a unanimous decision. Justice Neil Gorsuch wrote the opinion. Every other justice signed on. The court did 3 things. First, it rejected the Supremacy Clause defense outright. The FTCA's liability rule already incorporates the law of the state where the conduct happened. The Supremacy Clause does not give federal officers a separate immunity above what Congress already gave them in the statute. If Congress wrote a tort waiver that picks up state law, federal employees are subject to that state law. End of that argument. Second, the court clarified the relationship between the discretionary function exception and the law enforcement proviso. Some lower courts had been treating the proviso as a kind of override. Once you have law enforcement officers committing assault or battery, the case proceeds, full stop. The Supreme Court said no. The proviso saves a claim from the intentional tort exception. It does not save a claim that is independently barred by the discretionary function exception. The analysis is layered. Third, the court remanded the case to the 11th Circuit to apply the corrected framework. The lower court now has to decide whether the discretionary function exception bars the family's negligence or intentional tort claims, and if not, whether Georgia tort law would impose liability. I want to be very careful with you here. This is not a win for the family yet. It is a win on the framework. The exact same 11th Circuit that originally threw the case out is the one now applying the corrected analysis. They can still rule against the family if they characterize the FBI's decisions as discretionary policy judgments rather than mistakes in execution. That is what the new Fifth Circuit case is about, and it is why the family just filed the supplemental authority. But before I get to that case, I owe you a quick aside that the source coverage I'm building on glossed over. The Fourth Amendment. When the audience comments asked if they hit the wrong house, that was warrantless. Those comments are constitutionally correct. The Fourth Amendment requires warrants to particularly describe the place to be searched. A warrant for House A does not authorize entry into House B. The execution at the Martin home was, in substance, warrantless. The catch is that the Fourth Amendment angle and the FTCA angle live in different doctrines. The Martin family is pursuing the FTCA path, suing the United States itself for the tortious conduct of its employees. A separate path called a Bivens action would let you sue the individual officers personally for the Fourth Amendment violation, but the Supreme Court has narrowed Bivens almost out of existence over the last decade, especially after a case called Egbert versus Boole in 2022. So in practice, the FTCA route is the only realistic one for most wrong house raid victims today. Now the new Fifth Circuit case. The armed scholar coverage I am building on calls this case Morse. The actual name is Morris versus United States, decided May 18, 2026, by the Fifth Circuit Court of Appeals. The facts are unrelated to a wrong house raid. A woman on federal supervised release had reported specific death threats from her ex-boyfriend to her supervising probation officer. The officer made the discretionary decision to seek an expedited arrest warrant against the ex. Then the officer failed for several days to actually execute that plan. The ex attacked her in the gap. She sued under the FTCA. The government argued the discretionary function exception barred everything because deciding what intervention to take is a policy judgment. The Fifth Circuit said no, and the rule they articulated is the lever the Martin family just pulled. The Fifth Circuit drew a line between two things: choosing a course of action, which often involves policy judgment and which is protected, and executing that chosen course of action, which is often nothing more than ordinary care and which is not protected. Once the probation officer decided to seek the warrant, the failure to act for days afterward was an execution failure, not a policy judgment. The discretionary function exception did not apply. Now apply that line to Atlanta. The FBI team made a policy-level decision to assemble, plan an entry, and execute a warrant at a specific address. Whatever happened up to that point may genuinely involve discretion. But what happened after, the lead agent using his personal phone GPS to navigate instead of verifying the warrant's actual address, that is execution. That is the dropped checklist step. Under the Morris framework, execution is not shielded. That is exactly the argument the Martin family is putting in front of the 11th Circuit right now. The Justice Department is fighting back, arguing that the Morris case is distinguishable because the FBI's choices in Atlanta were intertwined with operational planning, not a clean cut between decision and execution. They are asking the 11th Circuit to read Morris narrowly and reject its application. The audience also asked a question that the armed scholar coverage did not address directly, and I think it deserves a sober answer. What happens if a family inside the wrong house grabs a firearm and shoots back? The closest precedent is the Kenneth Walker case. March 13, 2020, Louisville, Kentucky. Police officers executed a no-knock-style raid at the apartment of Breonna Taylor and her boyfriend, Kenneth Walker. Walker, who legally owned a firearm, fired one shot through the door at officers he reasonably believed were intruders. He hit Sergeant Jonathan Mattingly in the leg. Officers returned fire. Breonna Taylor was killed in the doorway. Walker was initially charged with attempted murder of a police officer and first-degree assault. Prosecutors dropped those charges in May 2020, after concluding they could not convict him given his plausible self-defense claim. In March 2021, Jefferson County Circuit Court Judge Olu Stevens dismissed the charges permanently, with prejudice, under Kentucky's Castle Doctrine. Walker can never be charged again on those facts. So, the legal doctrine does exist. A resident who reasonably does not know that the people breaking down their door are police officers can invoke self-defense. The courts have recognized that, but I want you to hold that next to the reality of the same case. Kenneth Walker was not killed only because the bullets did not find him. Breonna Taylor was killed in the same incident. Walker faced criminal charges for a year before the system caught up to the doctrine. The doctrine is real, but the practical risk to anyone who fires at officers in the dark is catastrophic. I am not here to tell you whether to keep a gun by the bed. I am here to tell you that the legal framework recognizes self-defense in this scenario, and the practical framework will probably kill you anyway. So where does this leave the Martin family today? The 11th Circuit ruling on remand is pending as of this recording. If the panel reads the Morris framework broadly, the family clears the discretionary function bar and the case proceeds to merits under Georgia tort law. They could finally be compensated for what happened on October 18, 2017. If the panel reads Morris narrowly, the family loses again, and the Supreme Court's 9-0 rebuke turns out to have been worth a procedural rewind and nothing more. And the bigger picture for citizens watching this: what does this case actually buy us if Trina Martin wins? It does not abolish qualified immunity. That is a different doctrine for suing individual officers personally under Section 1983, and it is not in front of the Supreme Court in this case. It does not revive Bivens. Individual federal agents are still largely untouchable for constitutional torts after Egbert v. Boole. It does not stop wrong house raids from happening. The same protocol that put an FBI SWAT team at the wrong driveway in 2017 is the same protocol federal agencies use today. What it does, if the family ultimately wins, is force the federal government as an institution to write a check, to internalize the cost of its own mistakes. And institutions that pay for their mistakes tend, over time, to make fewer of them. That is the entire game. Not a sweeping immunity overhaul, not a victory for the gun rights side or the gun control side, a single family in Atlanta trying to make the United States government answerable for what its agents did to them at 4 a.m. 8 years ago. If the 11th Circuit rules in their favor in the coming weeks, the Justice Department will probably seek further review and we will be back in this same circle. If the 11th Circuit rules against them, the family's options narrow to another Supreme Court petition. I will track the 11th Circuit docket and come back to you the moment a decision drops. If you want to be the first to know, the way to do that is to subscribe. Until then, pay attention to which side argues for accountability and which side argues for immunity. That distinction is not partisan. It is not red or blue. It is the question of whether the people who work for you can be held answerable when they get something this wrong.